Can police officers run a criminal history check as a matter of routine during a traffic stop? My name is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue Gold Law Enforcement Training, bringing you another roadside chat. All right. This officer, he wants to know, look, where I'm at a traffic stop, can I check criminal history? Specifically, if the person is armed. Now, they have constitutional carry in this state, so they don't need a concealed weapons permit, but the officer wants to make sure the person is not a felon. Can we do that without violating this person's rights, without unlawfully extending the traffic stop? And the answer is going to be yes. So, criminal history is generally speaking part of a traffic stop. It's part of your investigation. You want to know who you're out with, right? It's part of officer safety. I'm not saying that a speeding violation, you really need to know their criminal history to solve that crime. That's not my point. My point is that the courts generally have not held that running a person's criminal history unreasonably extends a traffic stop, because that is information that officers have the authority to know. Really, the best cases here, and this officer's in the Fifth Circuit. So the two cases here are United States versus Estrada, Estrada. This is a case from the Fifth Circuit, 2006. So U.S. versus Estrada, Fifth Circuit, 2006. And another case of the Eighth Circuit is United States versus Salazar, a case of the Eighth Circuit, 2006. Look up those cases and you'll see that this stands for this proposition here. The one little wrinkle I have seen out there is this. Is NCIC and some of these like federal databases and state databases as well, including Georgia, some in Georgia, like Georgia's criminal history database and so forth. They have rules. And oftentimes their rules will say something like, officers may not run criminal history unless there is some kind of investigative need, right? In other words, they're not allowed to just I'll give you a great example, okay, is running people registered at a hotel. So police oftentimes will ask a hotel for their registry. They can't compel it, okay? There's a Supreme Court case on that where, LA had a law that compelled hotels, motels, and the Holiday Inn to give over their registry to law enforcement, and they just routinely just ran people for wants. Okay, you can't do that. Okay, that's an intrusion. It's an intrusion on the business. By the way, it's an intrusion on the business. Okay, but you can still ask, because that's the third-party data doctrine. The hotel still possesses information that they got lawfully. Lawfully, this patron, this guest, gave their information to the hotel. And now this hotel is going to take their name and give it to law enforcement or their identification. That is the third-party data doctrine with the state of case law today. And at this time of recording this, there is no case under the Fourth Amendment, under the U.S. Supreme Court case, that says that is private information. There could be some state laws that restrict that disallow that, but definitely it's not a privacy issue. So a lot of states do it. But go back to the state database. Well, if you're just running random people through the NCIC or your state database, and they have this rule. I know NCIC does, but they have this rule that you're not supposed to do it without an investigative purpose. Where does that leave us? That leaves us with breaking the rules. Okay, that leaves us with NCIC auditors can say, put your hand out and let me slap it. Stop doing that. And why do they even have these rules? They don't have the rules because the Constitution disallows it. They have the rules because they don't want their system to be overloaded with cops running their babysitter, right? With cops running people they have a little side gig, a little side job or something, and just running people, or they're running their friends' friends. The point is, they want legitimate purposes so we don't abuse the system and have like a PR issue. We're not flooding our database with these random names because we just got 10,000 names from some business. That's why the rules exist. It's just for management purposes. But violating a rule does not mean you violate the Constitution. They're completely separate. Okay? But there could be other issues there. Maybe there's a state law claim. I don't deal with that. I'm just talking about the Constitution. So to answer your question, going back to this example of the guy with the gun, most cops are going to run that person. Most cops are going to see if, they're going to ask dispatch, or they're going to go through the MDT, their computer, to check for the person to have convictions. And it's not a problem. That is an investigative purpose. You do have a person with a firearm and so forth. Now, the courts do, talk about and suggest, a little pro tip for you, is that should be done at the beginning of the traffic stop. The same time that you're running the person for once and checking their license. That's when you should start that III, NCIC, whatever you're going to call it, so that we don't add a bunch of time to the end of the traffic stop. All right? That's what I have for you. I hope it helps. Keep the questions coming. If you like what we're doing out here, please, it's a favor. You don't have to do it, but it helps. Like, subscribe, share with your friends. All right? Until next time, my friends, you stay safe and make good case law.